Today we have a very, very special guest on our show. He is a patent attorney who used to work with a big corporation and is now in tech transfer. Super excited to have him on the show. He's also a very good friend, and I'm really grateful that he's going to be here to share his experiences with all of us. So let's bring on Dave Narasimhan. Dave, what's going on?
Pretty good, Amir. I'm doing pretty well. It's Friday. The weather is somewhat beautiful in Seattle. But yeah, I'm excited to be here. Thank you for the invite.
So Dave, your experience is really interesting. So you're a patent attorney, but you're in-house initially, right?
Yeah. I had an interesting trajectory. I really didn't experience the private practice side of patent law. Shortly after law school, I worked for a year at a patent search firm, and I went straight into in-house for a footwear and apparel company, and I spent 4 years there learning about foreign filings, how to manage outside counsel. It was a wonderful experience, but it was also very daunting because usually, attorneys work in like a few years in private practice and then move towards in-house or another place.
So I was always super impressed with that jump that you made from a search firm to a corporation for the very reason that you just said. I mean, the trajectory that I'm usually familiar with and that most people think is, oh, you want to work for a big company? Oh, well, you got to go work at some big brand firm for 4, 6, 8, 10 years, and then maybe you'll have a shot at the front door when you're applying to a big company. So I was always super impressed that you made that transition, because it's hard. There's a lot of competition. A lot of lawyers are tired of the billable hour, and so they want to go in-house and work for a company. Not to say that working at a company is a lot of work, but it's different, right? There's a lot of competition. Can you talk a little bit about what a search firm is like? Because search firms are interesting, right? Because not everyone at search firms are lawyers, right?
Correct. Yeah, most searchers are engineers, scientists, people with vast technical experience. The analysts or searchers I've worked with have been in the industry for decades. Some have just come from college and are learning about the examination side of patents. And it's a wide range of technologies, but most everyone who are searchers have some form of experience, and so they're able to bring their technical expertise to invention disclosures or to applications that they're searching.
So basically, the way it works at a search firm, sometimes we outsource it. It just depends on, it's a case-by-case basis, but basically, you guys will get some write-up. Maybe sometimes it's like a provisional application or something from counsel or directly from an individual inventor, and then you take that and then you spend about 8 hours, and you try to find as much of the closest priority as you can. Did I pretty much sum up the process?
Yeah, actually, yeah, no, that's pretty much sums it up. I mean, it also depends on the search as well. Most search firms do patentability searches. Some do invalidity searches, freedom to operate searches, or just a landscape analysis. And I think a disclaimer in this as well. The searches is only as good as the time that's put into it and how much time they have. The more time the searchers have, the more robust the report will be. If you're looking for a quick search, they definitely could do that too. In some cases, it's not always going to be good.
This is a key thing that we always tell our clients. It's like the search is only as good as the amount of resources that you put into it. So if you're only putting in 1,500, 2K, or less, maybe 500 on a search, you're not going to overturn as much prior art as if it's an issued patent being litigated where they're spending tens of thousands, or if not even more, hundreds of thousands, right? Depending on the case and the value of the case, right?
And it also depends on what they receive as well. If a client just gives a picture and says, "Here, search this," without any additional context, obviously it's not going to be as effective as giving a description and giving 3 figures or 5 figures to say, "Here are the features that we're focusing on." And this is important as well. When you're sending out an invention disclosure, you want to make sure that you highlight the novel features of the inventive features, so that it gives the search firms a chance to constrain for time. They could just focus on that at least and say, okay, let's search here, and they'll know what technology to search for.
Why are all your search results on the electronics? My invention's on the hinge that holds the lid.
Yeah, exactly.
Yeah. Did that ever happen where like a searcher quote unquote misses the boat because of what you just said, because you got garbage in?
Yeah, I mean, there are times where if you have received something, like we have sent out something because we had to send it to get a quick report or to or in some cases, we didn't really have as good of information to send it to send in the first place. And so it depends. And also there are cases where we've legitimately laid out the information, saying here, here's what the focus is. And in some cases, when I think when I'm working with researchers and I send a published manuscript that's been published after a provisional application has been filed, that gives, that they have more information there. It's a more robust manuscript. And in some cases, there are times where they miss the point. And so that's something to watch out. But I mean, in most cases, like I've worked, I think everyone, like most everything as long as we have like the right materials, they've been really good in, honing in on the inventive features and what the study really was aiming for, rather than obviously A, B, and C are disclosed, but used in a different way. This is actually more inventive than probably what they've seen. So they're very good about that. There'll be times where they say, well, the prior art has generally discloses these elements, but we haven't seen anything specific as to say like putting them all together or using a specific instance of this. So it's at least it's good. So you're going to get a little bit of both. The bad part is when you have to, you see a bunch of references and you have to sift through all of them. But it's, that means at least they found a lot rather than not finding enough. So
exactly, and maybe save the applicant a lot of money, especially if they're interested in worldwide and trying to pursue foreign patents, right? Also, that could save you a lot of money if the decision is, well, let's not file, or let's be super narrow on what we're claiming. So the profession has always been really interesting to me because you have all these different parties involved. Some of them have no legal training at all, right? Like patent examiners, in the case some searchers. The licensing is very different for our profession, right? We have to have a technical degree. There's exceptions, I guess. I mean, I guess you can do coursework, or you can take like the EIT, the engineering or the fundamentals of engineering exam. But for the most part, you got to have a 4-year engineering degree or science degree, and then you got to go to law school, and then you have to pass. In addition to a state bar, you also have to pass patent bar. It's pretty involved. I was just kind of curious for you. So what was that transition like between engineering, you did biochem, right?
Biomedical engineering.
Yeah. Oh, biomedical engineering. What was the transition like from biomedical to law school? Hardcore lab, I'm sure, to Socratic method.
Yeah, it's definitely been like a jarring experience. Ultimately I found my step and I was able to go through it. But the hard part was figuring out to look at all the viewpoints, not just the right one. So I think that's always been a difficult thing. Coming from an engineering background, we just looked at one answer and then we said, this is the absolute final answer. There's nothing to it because we have math, we have the data, we have the math, we have the science to back it up. With law school, I think when I came in...
law school was so hard for me, Dave? That makes sense.
Oh, yeah, no,
right,
yeah,
though.
that's...
We arrived to the solution. Here's how. But law school is about this perspective. Let's weigh them both, and this perspective should win because of this.
No, exactly. Yeah, it's just, even if it's the perspective, even if the other perspective is not, or even if the defense is, they could argue that, but your chances of success are not going to be good. Like it's just, you could mention that, but then when in exams they want like a full detailed explanation of any possible defenses or alternate theories, and so it was a little bit tricky because I always say, well, I could spend time talking about these other ideas, but ultimately, objectively, this is the right idea. So I'll just passively mention the others and then just focus more on this. So in some cases, it does depend on the class and the exam, and the teacher. But it did take me a while to consider. Okay, I do have to consider all the possible viewpoints and see, and maybe it could be mitigated by some factors. But for me, definitely, it was just I just focused on the one answer and said, nope, that's it. Because I know that the facts say this.
Yeah, that's probably one of the best answers I've heard. Because you're right. Really, it's like we reach a solution, we state it, and move on to the next problem, right? In the set.
Yeah, it's like, okay, let's do the next question.
Yeah, the one question that I never always throws me off guard is the why law school thing. But were you always, was it something that you discovered during undergrad as a possible career? Or was it something that was always in the back of your mind? Because for me, it was always in the back of my mind. It was always something that I was really interested in. I always wanted to study the law. To me, it would always seem like a really cool intersection. What's your feel on that?
Yeah, so I originally wanted to I was thinking about med school, I think when I first entered college, but I really liked engineering more. I felt like I wanted to work with that more.
Was this a revelation in OChem, or was it gradual?
I think it was more gradual because I really wasn't more into the engineering aspect of, or not the engineering, but the research aspect of it. I was more into designing and inventing and wanting to be able to design the medical devices rather than just doing straight research into wondering how measuring the expression of a cell. So I wanted to really get more creative. But I think at the time my program it was great for doing research and preparing you for medical school and preparing you to go into the to do doctorate level research for for straight engineering though it's at the time, it was still a fairly new program, and so they weren't focusing on that. They weren't focusing on that as much, and so for me, I felt like I wanted to do something different, and so I learned about patent law, and I learned that there's always a need for patent attorneys because it's an area that not a lot of people go into. No one wants to go through that much schooling for engineering, only to go to additional schooling for law school, and then take a patent bar in addition to a bar exam. It's a glutton for punishment, as most people would say. So I think that's probably why I said, well, okay, I'll give it a shot. And I mean, I got to say, I think there are times where I wondered, wow, I guess it would have gone in a different direction if it didn't work out. But knock on wood. But I mean, I took the LSAT, which I thought was difficult. Of course, now looking at it, I think it's probably would be easier now than it would be earlier. But I did enjoy the logic games. Went through law school, and then then during that time I took the patent bar, which allowed me to not worry about it.
That's what I did too. Actually, I did it before law school. I did it right like the summer before.
No, that's really good. It's always good to get it out of the way. I think my advice would be if you're able to do it early, if you know you want to take the test and you want to become a patent agent, it's the best way to go because at least then you have that out of the way and then you can try it out. And if you do want to go to law school later on, or if you're in law school and you want to take it, I would take it before you take the bar exam. It's just one less thing to worry about. Yeah.
So from the search firm to going in-house, like what did you use a headhunter? Like how did that work?
Probably this is gonna shock a lot of people. I just applied. I just really I found the opening online. Might have been Indeed, I think actually. I just applied. I just kind of went and said I'm gonna I kid you not. I went ahead and applied and just went through the normal interview process and I got in. I think there at the time
door.
Yeah, yeah, exactly. No, yeah, the corporate entrance. Yeah, no, it was a really mind-boggling experience because I had the same feeling I had the same thought you did. I thought, well, there's going to be many people going for this.
So when you were submitting, were you telling yourself, oh, this is a crapshoot, like let's just see like what happens, type of thing, or
more likely, yeah. I thought, well, we'll see what happens. It looks interesting. I mean, it's just in the sense that, I probably may or may not get it. I don't know. We'll see what happens. They were looking to expand their U.S. side. Most of the patent attorneys at the company are all in Germany. So most of the innovation took place there, but they were looking to expand their U.S. side because their U.S. side was also doing innovation. They're doing more innovation at the time, so they needed someone to help with that. So they were, and then also they wanted to do more like in-house searching to help with that, just to bring down the cost. So
was that sort of your angle? Was that kind of your angle? It's like, oh, well, I have all this experience searching, or
it didn't hurt. I think also, I think they were also looking for someone I think that would help to grow as well, because at the time I think it was a fairly new position, and I think in some corporations the legal departments tend to be more senior. It's more senior heavy than I think new associate heavy, and that's something I think to look out for as well. It's great. I got a lot of experience. I learned a lot. You also want to be in areas that help you to grow as well and learn new skill sets, because there are some that will, as you go in house in some areas you'll be compartmentalized, and so there's some have specific tasks, and so if you there are times where I received a contracts question and I was told to forward it to legal counsel because that was their area, and for me, my time was better suited for patents, so which is understandable, but at the same time you're going to encounter you will encounter that, and it's not. You just have to remember it's not personal. It's just the way to tell people.
But in that crossfire, I'm sure you're going to learn some interesting things when you farm something out and it comes back. I mean, it comes through your inbox, and I'm sure you have to review it and provide your client, which is the company, the advice, right?
Yeah, of course. Yeah. Oh, yeah. And we also think about what markets this would be good, this new innovation would be good for. How to determine filing strategy. Also, how crowded the space is. some competitors have almost a near monopoly on some technologies than others, and so we have to take into account of that. We also have to look to see if we have to file in the U.S. first or other countries. We also have to see like how many units that this is going to sell, or what's the market for the product. Like if it's going to be in a certain sport that's more coveted than others, then we have to take that into consideration. So it's really, we learn a lot more about the business as well, and we learn how that factors into our decisions.
Yeah, that's another really cool thing I think that you probably don't get as much when you're working at a firm. Like obviously, to be a good practitioner, you need to always take economics, and you have to have an understanding of the client's business, right, to do a good job, I think, right?
Yeah.
But ultimately, do you want to do A or do you want to do B? A costs this much, B I think costs this much. Okay, like that's usually where the analysis ends for the practitioner. You just wait for the answer. But I'm assuming that your experience is you actually get to be there to see like how that A or B decision gets made, and like what the trade-off is, like what the real trade-off is.
Yeah. We so in-house counsel will think about the long game as well. When they look at a technology, they look to see, okay, well, what divisionals or continuations can we spin off from? And outside counsel should be asking these questions as well, in my opinion, to say, hey, here's what you should think about.
If you want to do a good job, yeah.
Yeah, of course, yeah. Like just if you want to think about this, but ultimately, it's up to what the client wants. But at the same time, it's good to plant that seed in there because it tells them, okay, this is maybe what I should be thinking about. And in-house counsel should be doing the same as well, to say, we can plan for this one-off application, but we have more material to do divisionals. We should take advantage of that, especially if it's going to be a key technology that's going to be part of the business. You want to keep those. Those applications pending, especially if they could serve as like defensive publications against their competitors. Usually, you can tell the strength of a publication or a patent by seeing how many applications or patents are citing it. If you see it in the hundreds, it's going to be it's more likely going to be a stronger publication. Yeah,
that's actually a really good that's a pro tip right there. Looking at the number of times it's cited.
You also have to consider how much it's going to cost to maintain it. If you have one or two patents, it's not as much, but if you have dozens, costs are going to add up as well. So that's something you have to consider, and that's something we were considering as well. We thought, well, this is a good technology, but this is really being used, and that's where we have to cut the cord at times.
My general experience with corporate clients is so the really, really big ones sometimes have their own internal filing teams where sometimes they do the work in-house, but if they farm it out, the work comes back and then they file it. Or sometimes if it's smaller, or just depending on the relationship, sometimes the firm just files the applications, right?
Yeah, and some big companies do that too. They'll just have counsel file it themselves. Like they'll have their outside counsel just file it, and then they send the final report to the in-house paralegals or to the in-house counsel. They would just record the information. They would record the information and calendar the date, the important dates, or they would sometimes report it to the inventors. There are times where some companies report to the inventors and some don't. It depends. Like there have been cases where I think some inventors have been interested in saying, can you send me the patent application? I want to see what it looks like. Or there have been times where they probably forgot they even had a patent until someone reached out to them to ask them about the office action. I've definitely seen both extremes.
Yeah, I mean, the heavy question, like one of the things I like to ask people is just how do you incentivize your employees to submit invention disclosure forms and to spend the resources and time into actually procuring patents? Because I guess one conservative opinion is, well, if they're engineers, they're engineer employees, they're actually hired to innovate. And so part of innovation is working on patents. And so it's tough because it really does take a lot of time. It takes a lot of effort. And so like I know some companies have patent rewards programs. Some, I think my personal opinion is the ones that are able to make it so that it's clicky where, if you want to have like this cool hoodie or like this bumper sticker or this plaque, or actually I don't think plaque, but like just something unusual that indicates that you're part of the cool club. Yeah, I don't know. Was that? Do you have thoughts on all that, or is it like cold hard cash? Like you got to just have like as much cash as possible.
No, it's interesting you bring it up because most. At least on the U.S. side, companies argue that the salary is enough. Is enough to be considered as consideration in exchange for assignment of rights. And so it depends on the company, but so some companies in general do incentivize their employees in addition to their salary. Whether it's one in consideration for $1 or or if they want, or in a consideration for like a certain allowance for towards a towards their team or to the group of inventors, or even a plaque, like you said. It does depend on the company and what they want to do with it, but it is getting better. I know it's different in some countries. I know Germany, they ensure that the inventors are well compensated for their innovations, and if they were to leave a company,
so separate from their income.
Yeah, separate from their income.
Okay, I didn't know that.
Yeah, so some companies generally, Germany has laws where they they're very friendly towards the inventors, and the more innovations you do and you assign to the company, then at the end they can ask for like a modest sum. It depends on, some inventors have gone due to that, and it's better protected for the inventors. The U.S. side is also getting better as well. I think it also depends on it depends on what the company is doing and like how they treat their employees. So
generally, whenever I hear tech transfer, I always think, okay, well, it's IP licensing in an educational or research context. What was that transition like?
University of Washington is a great organization. I'm learning a lot. I'm learning a lot how the Bayh-Dole Act. So when you work for an academic organization or a nonprofit or actually any organization for that matter, that when you take funding from
grants, right?
Yeah, when you take federal grants, you want to make sure that you're in compliance with the Bayh-Dole Act and you're following all the rules there. You learn the effects of joint ownership or co-ownership or sharing IP is more prevalent than it is on the corporate side. Corporations in general don't like to have joint IP unless they absolutely have to, some in my experience. And then so we consider the effects of that as well as how that comes into play with licensing. We work with our licensing managers to ensure that all the technologies that come out come from our researchers are licensed or they're commercialized.
Basically, you have these universities or research institutions, and the idea is that when they innovate, when they create these innovations, they're going to file patents and own the patents. But then, as a source of revenue, they then license those patents to private industry so that they can actually practice those inventions. And then the research institutions obviously get royalties from the licenses so that they can continue on with and develop their programs further. Does that kind of sum up?
Yeah, our licensing managers reach out to corporations,
and sometimes they come to you, right? Sometimes
they would come to us in the sense that if they needed some patent questions asked or answered, we would help them with that. Also, some like researchers are now coming up with their own startups as well, and so they're working to secure funding, and they use their IP that they get. They use the IP that they receive through patents to help with that. And
doesn't that get super hairy though? Ownership, like that. This is what I guess what you're saying is because once the Bayh-Dole Act comes into play, now don't you have an obligation to license to the government?
The Bayh-Dole Act does give them the government the right to march in. If an organization decides to retain title of the invention, one of the requirements is that it gives the government the right to march in if they ever need to. Of course, that being said, there has to be extenuating circumstances for it to do that. So I advise to check with your practitioner to make sure that if you feel that you're working with Bayh-Dole Act, and I encourage that the clients reach out to their practitioners to check on that, and also to, if I remember correctly, it also does give the government the right to use it, but again, it's only in certain circumstances when I think certain requirements on that side. Again, and that's something I would check in detail with anyone.
So it's not usually like a turnoff then for like private investors. You just have to make sure that all the title and all the assignments are done correctly. Is that?
Well, you just have to essentially report it. You just have to report the funding, just so that it's well known. Let's say, I'm just going to say off the top of my head, like let's say government X or government agency X is coming in, or gave you funding for this. Then when you file the application, you have to say
there's like a section. There's like a paragraph you have to say.
And you say the government has certain rights to the invention.
And it's in the application data sheet, I think, and like even in the provisional, I think there's a box in the provisional cover sheet where you have to mark it.
Yeah, and that carries out throughout the all the filings. So it's best to keep that consistent. And also like another thing as well, just to make sure. And that's actually a good segue into what people with academic institutions with joint ownership is. The European Patent Court released a decision where I think the ownership was at issue, and the court ruled that because ownership was not kept, but the ownership has to be kept consistent at this time to file, at the time of the provisional throughout the fully fledged application. When you're doing provisionals, you want to make sure that ownership is consistent throughout the patent stage, because it has to be the same. So I'll give you a scenario. It's bad when you have two joint owners on a provisional patent application, but then when it comes time to file a PCT or non-provisional, or PCT for that matter, then
you drop one of the inventors.
No, you drop one of the owners. So one of the applicants.
Yeah.
And so if you have A and B, and then only A wants to file in the application and or wants to follow up with a non-provisional, or not non-provisional, but PCT, and B doesn't want any part of it, that's going to present a problem. If you have if you have A and B want to follow through with the PCT, and then C comes in, that's not going to be an issue, because the ownership is still kept the same. It's when the ownership is different from the provisional that it's missing an owner. So. And that affects its priority. Yeah.
What really keeps you busy in internals? Is it working licensing deals, or is it reviewing IDFs and getting the applications to the point of filing, or what sort of where are your efforts spent?
It's more spent reviewing subject matter received from the inventors and determining what extent, if any, how much has been publicly disclosed versus could be covered. There have been cases where an inventor would come in and want to file on something and say, well, we have this manuscript that we published, and so we want to check to make sure that.
We published it 16 months ago.
Yeah, and that's where we check to see. Well, we check to make sure that nothing, there's anything that could be salvaged. And in some cases that they are, I help to at least focus on those features, because if they will still want to file, we could do that. But we also let them know that in some cases we can't. We may not be able to, because we can't get protection on this. But
break hearts all day is what you're saying.
Either that, or I save the day. Yeah.
Yeah. Well, you didn't disclose that particular detail, so let's do an application on that detail.
And that's pretty much what it comes down to, on most times. But I mean, some of the researchers, most of them have been more are really savvy on the patent side, and so they'll know what to say and what not to say when they publish a manuscript, or
that's so cool.
Or they check with us beforehand saying, hey, we want to submit this manuscript, but we want to have this on file first before we do so. They're getting better at that, and the licensing managers help with that as well. They help relay that information, when it comes time for commercialization. So and our licensing managers are very knowledgeable on the patent side. We work closely with them when it comes to patent related matters. So.
Yeah, this issue is complicated because the 1-year rule is really, that's fine in the US, but so basically the 1-year rule, you have a year from publication or disclosure to file a patent, right? As long as the disclosure comes from the inventor. But that's not always the case in foreign jurisdictions, right? Which is why you got to be really careful. Aren't some jurisdictions stricter on that?
Well, some are. So I know at least some are. US is not the only jurisdiction that has some grace period. Most do not have that grace period. So we always err on the side of caution and try to avoid it altogether, and just say, regardless of whether or not this will only be for the US, let's just file on the safe side and say, keep our options open. So Europe is big. I think that's always been a big one. We've always tried to. Europe is a valuable market, as well as and I know there's a few other countries as well that have that. It's either Japan or China that has probably a grace period. My advice would just be assume that no country has a grace period and just file it as early as you can.
Don't find out about it is the key, right? Don't learn about it. I just think it's so cool that you get to work with all these innovators and researchers, but you're in the context of startup land, right? I just think that's awesome. And probably the inventions you get are really different, right?
It spans across different technologies. I'm currently more focused on some life sciences, some chemistry, some biomaterials, 3D additive manufacturing, 3D printing, some chemical engineering. So I do a little bit of everything.
You do everything. That's awesome.
It's spanned across different technologies. We have one where we have one person that does purely engineering. He worked in the industry prior, and he works with electrical software, mechanical. My boss is working on pure life sciences. She's worked in the industry prior as well, and she's worked. She's advised for many biotech companies, and so she brings that expertise as well. And so So I help with a little bit of everything on their sides, but yeah, each person has their own expertise, and it's yeah, and it works really well. So
what's your one parting gift to innovators? So people that are either engineers, inventors, trying to start a business, like what's your one tip if you could give them one tip?
I think my one tip would be, if you're looking to file an application, focus on the features that you want to commercialize first, while also thinking about what you want to have planned for the next 5 years. I mean, it could depend on the product and I guess your timeline, but focus when you're planning an application, provisional and non-provisional, make sure you tell your outside counsel or your attorney that what features you want to focus on, what you have planned for, and
because you want to have a lot of detail, obviously, in that novel area.
And just and make sure it's enabled.
So important. Dave, thank you so much. Thanks for being on this.
Happy to do this. So yeah, anytime.